So I guess with that, I got a little time left if you have any questions for us.
Okay, just to clarify, when you have an extension of overriding interest with a lease, does that apply to any oil company that gets that lease later on? I had an issue with the title requirement where one company had the lease and there was that extension on that original lease, and then another company later on took the top lease, and the title requirement was that they were subject to that extension.
I wouldn't think so. There has to
Okay.
be some privity there in the chain of title. You know, even though, you know, like in my example that I gave, if A and B had these transactions, and now C as an oil company bought that lease, there's some privity there, you know. But if it's a totally different company taking the same a new lease
Right.
from that mineral owner, no, there's no. I would say there's no extension.
On the railroad right-of-way issues, do you figure out which act applies by seeing which railroad has the right-of-way, or is there a list of sections that each act applies to, or did the later of the acts just override the previous two, the 1800 acts that determine whether or not the railroads get the minerals with the conveyance, or how do you determine which act applies to determining if the railroads got the minerals?
Well, you basically know if you're up on the northern tier, you know, Minot, Stanley, Williston, that's Great Northern. It just is the Great Northern. That's an easement only, okay? If you're down, you know, from Bismarck, Dickinson, Belfield, Medora, you know that's Northern Pacific. You know, it's this kind of unique situation of USA reserving oil and gas, but with a unique lease. So in some sense, it's just, we just know, okay? I don't, you know, there's really no, I mean, you can go and find the acts, but it doesn't tell you what lands it applies to. I mean, you can, if, you know, if you can find somebody with the railroad companies, good luck, you know, that can help you, you know, can you give me the maps of definite location, you know, in section 3 of 152, 103, Williams County, North Dakota, tell me, or let's say Stark County, because then you're concerned about oil and gas. You could potentially get those maps from the railroad. I think somebody told me that the Historical Society even has some of those regional railroad maps, but they're hard to come by.
And then, Chris, I think this was for you. What language ought you use in the deeds themselves then to avoid this Duhigg problem? If the reservation doesn't work in the face of the grant, do you just get really specific about the percentages you're actually conveying? Do you need a title opinion before you actually sign a mineral deed, or?
I mean, there's a couple ways you can take your conveyance out of Duhigg to make sure it doesn't apply. You can make it subject to prior mineral reservations, exceptions of record. That will say, you know, we take the position that if you make it subject to everything that's out there, you're not then purporting to convey extra. You're saying, I'm going to reserve 50% subject to everything else that's out there, so I'm not purporting to convey you anything, essentially, but I'm keeping 50%. So you can do that. Those subject to clauses are important. Otherwise, knowing the state of title, I mean, knowing what's out there and avoiding, I think, fractions and numbers altogether is always good. You know, if you own all the surface and half the minerals and you want to reserve your minerals, just reserve all the minerals. Don't use that 50%, because that's where you get tripped up by Duhigg. But if you just say I reserve everything, then you're fine. You don't have that issue. But you can take it out with that subject to clause as well. That's a good way to do it.
Brian, if you have a royalty conveyance, or that was created either by a conveyance or reservation, and you determine as a title examiner that it's subject to an existing oil and gas lease, and that royalty will be carved out of the lease, if that lease expires, and the conveyance is silent, is it understood that that royalty would extinguish when the lease expires, or will it perpetuate to a forthcoming lease to a third party?
In the examples I were giving, these are perpetual royalty interests. They are interests in real property which were created oftentimes in the 30s and 40s. They are perpetual royalty interests which will be there forever. They do not extinguish with the lease.
My question has to do with the frequently used term, "will send this out for stipulation of interest." And my question is, a little background from you on what that might entail, just for us who might not be familiar with those terms. And is that just to cover yourself at the end of your title opinion, or do they actually go out and get stipulations? How hard is it, and what happens behind the scenes?
Is it to cover ourselves? I suppose somewhat, yep. But really, you've got a title issue. As a title examiner, you're just really uncertain of who owns what. Now, are you talking maybe the royalty or the override thing, or?
Yeah, I'm talking about, are these things stipulations? Are they getting signed, and are they taking care of the title, kind of thing?
Yeah, I mean, obviously a stipulation of interest is where we tell the client, oil company, for instance, we can't tell if this is a fractional royalty or fraction of royalty. We have the ACOMA-WENCO issue of which mineral owners bear this royalty. We make judgment calls, we write the opinion up, but then we say, we got all these issues. We have just made a judgment call. We are not certain if this is what the parties meant or if they'll agree to this. Go out and get them all to sign a stipulation of interest. Do the companies do that? Most of the time they do. Not always. Some make a judgment call if it's a very, when you're doing these 1,280 acre spacing units, and if we're talking about a .0000238 interest, they may waive it, But if it's anything significant as mineral ownership, royalty ownership, they will oftentimes seek to get that stipulation of interest, yes. And if they're unable to get it because the parties disagree, like the WENCO case was where I think it was WENCO mineral interest, because they were the successors to the surface owner who conveyed this royalty way back when. They were saying, you should proportionally distribute this mineral interest between me and the other guy. And the other guy's saying, no, I got a mineral deed here, a 50% interest, warranty clause, not subject to anything. Heck no, I'm not going to sign a stip like that, So you try to get a stip. If you can't get it, quiet title action.
On the issue of affidavits of production, could it not be argued that where a lessee fails to file the affidavit of production, new lessee comes along, that the subsequent lessee was under a duty to inspect the property, and if he inspected the property, he might have seen a producing well, a pump jack, or a Christmas tree out there, and therefore he couldn't just say, well, you didn't file the affidavit of production, therefore you're out of luck.
Absolutely, yeah. I think you have a duty as that third-party lessee to inspect the property, determine if there's a well out there or any sort of operations going on. I don't think you're going to win the argument saying, well, there's no affidavit of production of record, but yeah, if I would have went out to the property, I would have seen the pump. Yeah, absolutely, there's a duty. And I think that's part of that notice. You can't have any sort of actual constructive inquiry notice, which would include inspecting the property and be a bona fide third-party lessee and win. I think, if those things are out there, you're going to lose.
I'm going to follow up on that same topic. So if an affidavit of production wasn't filed, but you go to the North Dakota Oil and Gas website, there's a producing well on it, or you can just tell, and the landowner goes and files that affidavit of non-production, which from what you're saying means that the lease is expired upon filing it, depending on what state you're in. I know there's certain procedures in Montana you have to go through. I've run into this issue a couple times in Montana where you're fighting with the landowner who's trying to say, oh no, that lease is expired. I'm going to go out and I'm going to lease this to someone else. You know, it seems strange to have a statute that says upon filing of that affidavit, you know, that all of a sudden that lease is just expired. Have you run into that issue?
Yeah, I mean, I don't, there's no automatic, at least in North Dakota, that if you file that affidavit of non-production, that's golden, and then that means that, you know, the lease is expired. It's certainly not automatic. I think it gives you some comfort as a lessee or as a third party that, you know, that maybe that lease isn't held. But you know, particularly like you said, when you've got the Industrial Commission website that's so good and easy to navigate and you can find wells, I wouldn't want to be on the arguing side that said, we know it was on the Industrial Commission website, but we didn't go there. I mean, we don't have any case law on that or clear authority as to whether the third party is required to go to the Industrial Commission site and determine that. But to me, that's the logical conclusion, that if you could have determined that based on the Industrial Commission site, you're probably not going to win, and you're not going to be a bona fide purchaser. I mean, I don't know. I can't imagine the court going the other way and saying, well, yeah, it's out there, but you don't need to look at that. So I think it's good that even though we've got kind of the statute we have that says, as a lessee, you better file the affidavit of production to protect your interest. It's always good as somebody who is looking at these things, or a third party or somebody who wants to lease those, you've got to do your homework, and you've got to go outside the records and make sure that you determine what's there. And so I think a lot of times you see, you know, the affidavits of non-production. When I'm examining title and I see them from a mineral owner or from an individual rather than the person at the Industrial Commission who's signing those things, I always question those a little bit more and kind of wonder, you know, is this really valid? And I don't give those as much credibility, I guess, as the ones that come from the Industrial Commission, you know, themselves. So it's definitely something that you got to look into further, I think, and make sure that you can show that you did your homework and that you went out and looked other places.
I have just a quick question. If you have a tract of land where the WANCO clearly applies and the oil company refuses to change their opinion, is a quiet title the only way to resolve it? Is that the only way to resolve that issue? And if it is, how can you get them to provide the names of the royalty and mineral owners in that tract and addresses?
Typically, the oil company, if there's an issue like this, will just probably do a suspense and notify the parties that, hey, you two have got to go take care of this. I don't know if that's answering your question, but.
And then if you can't resolve it with the other owners, you just have to do a quiet title?
Correct.
Actually,
Yeah.
Yeah, and I mean, I think it goes back kind of to that stipulation question. If you've got that issue and you've got a potential problem, if you're not going to get agreement between the parties, then certainly litigation's the only way that you're going to ultimately resolve it.
is there any way to get the oil companies to release the names of the royalty and mineral owners in the tract?
My guess is that would be up to the individual companies themselves as to whether they're, you know, willing and to do that. I mean, they're certainly under no obligation, I don't think, to do that, but, you know, whether they want to or not. But, I mean, you can also, the county records are there. They're open. You can go check them, see who owns what.
Hey, Chris, I'm curious, if you get a Stetson reservation, that's obviously an ineffective third-party reservation. How are you treating that? Because I've seen it where A conveys to B, reserves to C, and then A disappears and C's divvied it all up. And now my entire tract's in suspense.
Yeah, that's an interesting question. I mean, but I think, you know, if it's not a spouse, I think you still have to apply Stetson and say, you know, that reservation is likely invalid and you need to fix it somehow. I mean, whether it's I think as C and C's successors have a pretty good quiet title argument that, look, we've got this deed. Yeah, maybe it's void under Stetson, but it's evidence of the intent. And so we want a judgment saying that we own everything that A owned. But I think Stetson's still good law in terms of any third party other than a spouse, you can't reserve to them.
I guess, and my follow-up question in theory is, obviously A conveyed to B and reserved to C, and we apply Stetson, who would be the owner if we're going to cut C out? Is the reservation effective to A or B?
I believe that's I'm not 100% sure on this, but I believe Stetson's ruling says that A retains the minerals. Yeah, so if it's A to B, reserving to C, the C reservation is invalid and void, but A gets to keep whatever they had. So B is out no matter what.
I've got a question on conveyances dated back in the 1950s. Do the current title standards apply to those conveyances also?
Yeah, I mean, absolutely. I think the title standards apply. There could be statutory changes or case law changes. I mean, like some of these, but I think even then, that's one of the issues with the Malloy case as well, is it's an 83 case, but we apply it to deeds going back forever. And the Supreme Court didn't say that it's only prospective. They said this is the rule. So the rule is going back in time. So
Right.
the title standards, the statutes, the case law, unless otherwise stated, would apply.
All right, very good. Thank you.
I guess that's it. Thank you very much.